Hi everyone, I'm going to give you a few more seconds to log in now that you've come out of the waiting room. Okay, it looks like a lot of people logged on already, so welcome everybody to Sealing and Expungement of Adult Records in Florida. I'm Christy Bagalow, the Director of Statewide Training at Florida Legal Services, and we are so fortunate to have with us today Laura Maria Sanchez. She's a staff attorney at the Legal Aid Society of the Orange County Bar Association, and she will be teaching us all about sealing and expunging. And as we were planning this webinar, I kind of joked but not joked with her that I always envision the Staples easy button when we're talking about this, except that there is no easy button for sealing and expunging. So I'm glad Laura's going to be walking us through the process in Florida. This webinar is being recorded, and you will receive a recording in your email tomorrow from Zoom. I'll also be posting it to the Florida Legal Services YouTube page, so I'll post that link in the chat. We'll take questions at a few points throughout and at the end. So you can go ahead and type your questions into the Q&A box that should be at the bottom of your screen. And if you have any other questions or comments, you can type them in the chat box and I'll be monitoring the chat box. I think that's, oh, CLE. I promise I applied about 6 weeks ago. I am still waiting for the approval. So once I get the approval, I'll try to email everyone who registered. If all else fails, I'll put it on the YouTube page in the details section under the video. So thank you again, Laura, for doing this, and I'm going to hand it over to you.
Thank you. Hi. I hope everyone's staying safe with COVID and everyone's working good from home. As you can see, I am working from home as well. And today I want to talk to you guys about sealing and expungement in Florida. So let me give you a little bit of an idea of where I work. So I work for the Legal Aid Society here in Orange County. We are a nonprofit law firm. We handle everything from immigration, housing, consumer. We have a JL program that does the dependency system as well. And of course, sealing and expungement of records. Everything that we do is at no cost. It's for low-income individuals. We also have a tax clinic that we have during the tax season to prepare taxes as well at no cost. And we reopen that tax clinic throughout the year to do previous year taxes as well. So I just wanted to give you a little bit of an idea of what we do. And all right, so I'm gonna start just by making a point that sealing and expungement is a state-by-state law. So I will only be able to talk to you about today for sealing and expungement here in Florida. So if you have questions about another state, that wouldn't be something I could talk to you about today, but I could try and find the answer for you and let you know, or put you in contact with someone in that state that would do sealing and expungement as well, okay? So I wanna start by, oh, sorry, I think the PowerPoint went a little crazy, giving you an idea of what an expungement is and what a sealing is and the difference. So it does the same thing, it's just how the records are kept. So let's say you have a record on a shelf and you put it on the shelf. If it qualifies for expungement under Florida law, then you would have a card there that says there's a record here, but you cannot see it. If it's sealing, think of the same thing. They put tape on the record and they put a card there and says, hey, there's a record here, but you still can't see it. So it's really how it's kept. One is taped up and one is not. It's kind of a weird analogy, but a lot of people ask what is the difference, and there's really not a lot. It's just on how the record is kept and what charges qualify for expungement and what charges qualify for sealing. So for expungement, specifically, how you determine under Florida law which one qualifies for what is what happens at the end of the case. So it doesn't matter what the person pled at the beginning, it's what happened at the end once the case is completely closed out. So the disposition of that case. For cases where charges are dropped, there's no information filed, there's no indictment, no pros, all of that will fall under an expungement. If it's something where they were found not guilty after trial, or if it's adjudication withheld, then that will qualify for sealing. So you can't really determine on your own, hey, I want to go and expunge the charge or I want to seal it. No, the law will tell you exactly which one you can expunge and which one you can seal. It's also very important that every single case that the client has is completely closed. And the reason why is because every charge that that client has in the state of Florida has to qualify for sealing or for expungement before you can determine if they can seal or expunge. And I know it's weird, but for example, let's say somebody has a battery charge and somebody has a petty theft charge. So for the petty theft charge, all of the charges were dropped, right? For the battery, it was not. They were adjudicated. So what ends up happening is that Florida states that if you were ever found guilty of any criminal charge, you can never seal or expunge anything, even if the charge that you're trying to seal or expunge is the one that you were not adjudicated of. So if you're trying to seal that petty theft charge where it was adjudication withheld, but the battery charge you were adjudicated, you cannot seal or expunge that petty theft charge. It's very narrow and it's a little confusing. And a lot of clients don't understand that. Well, I didn't get adjudicated of that charge, so why can't I do it? Well, but you were adjudicated of your second charge. And that is why Florida says, no, you cannot seal or expunge any of that record. So it's definitely not a simple process. It's a little complicated at the beginning just to determine what qualifies or not. But once you get through it, it really is not that bad. So like I said, everything has to be closed out because you need to make sure that the entire record that your client has qualifies so you can seal or expunge that record. All right. So for expungement and sealing, the initial process is the same. So I always ask my clients, tell me what county you have a record in or you think you might have a record in. There's clients where they have a record in 5 different counties in the state of Florida. There's clients that only have 1, right? So the reason why is because, like I said before, you need to research the entire client record to make sure each of those charges will qualify either for sealing or for expungement. And the reason why is because we need to know what happened at the end to see if you would qualify under Florida law. Under Florida law, you can also only seal or expunge 1 record in your entire life. Like I said, it's very narrow. Florida doesn't make it simple for us. So most of the time I ask my clients if they have multiple records. They know the one that's really harming them when they're trying to find a job or they're trying to rent an apartment. They know the one that keeps coming up and employers say, no, that's not something that I want. So it could be a petty theft charge, it could be a battery charge. It really just depends on the one that's harming them the most, and let them know that that is final. So once it's sealed or expunged, they cannot go back and say, oh no, I don't want that charge, I want to do another charge. No, once it's done, and that it's your one in your lifetime that you will get to do that under Florida law. I always tell my clients as well, if they have charges in another state, I can't advise them on that. Make sure you let them know that you can only tell them about Florida, that it's a state by state law. I always also tell them, since clients are not always the most honest, right? To please tell me if they think they have a charge in a specific county, even if they don't know. And the reason why is because when you submit your application to the Florida Department of Law Enforcement, that is the agency that's involved with the sealing and expungement process here in Florida, they will not give you back the fees that go with that application if it gets rejected because they found a charge in another county that did not qualify and now the entire application is out. They will not give you back those fees. So once you tell clients that you have to pay something upfront and that if you lie and you're not completely honest with every single charge that they have, and you won't get that feedback when your application gets denied, they're pretty sure about telling you, okay, I might have a charge here, I might have a charge there. So it's very important that you try and find out everything that you need to know about those charges and in what counties they have them in. So I'm going to start with expungement. The process itself, it's not hard. The first thing you have to do is you have to fill out an application. and they are with the Florida Department of Law Enforcement. And at the end, I will go through the website so I can show you exactly where that will be. The application has to be signed and notarized by your client. And this is one step that you have to do for expungement, but not for sealing. And that is, you have to submit the application first to your state attorney. They have to approve it and make sure that they are okay with that client expunging that case. So once you get that approval from them, the state attorney signs it and sends it back to you. Here's where the fees come in. So the client has to get fingerprints done on a specific card, and I will show you what that looks like as well. At the end, they have to send a $75 fee with their application, and they also have to get a certified copy of the disposition of that case. So they have to send all of that to Florida Department of Law Enforcement. That's why I tell them, hey, you're gonna pay these fees, you're gonna get your fingerprints done, and if it doesn't qualify, or you didn't tell me everything about your particular charge, then it might get denied and you won't get those fees back. Now, this is the really kind of annoying part to me, how long it takes to really get an answer back from Florida Department of Law Enforcement. Right now, it's taken about 9 months. Normally, it's 8, but right now with COVID, it's taken about 9 months for them to let us know, hey, you're good, and they send you a certificate saying that your client has been approved to get this record expunged. So it takes a while. The process is not simple, and it's definitely not short. It takes a long time. So I always tell my clients from the beginning of the case, so from the time that you meet with them, go through the consultation, fill out the application, send it in, everything, it's about a year to a year and a half until closing of that case. So it is a little bit of a long process, but if you're able to get it done, I definitely think it's worth it for your clients. And a quick practice tip on this is I always send the packet to Florida Department of Law Enforcement certified mail with return receipt. And the reason why is because a lot of times they say they never got the application, or they lost it, or they can't find it. So at least you have proof that you did send it in and that someone signed for it. If not, then you have to start all over again, go to the state attorney, do a new application, do another $75 fee, do another fingerprint card, and you definitely don't want to do that to your client. So I always make sure that everything is sent out certified mail for that. Now, once you get your certificate, the next step is to file a petition in court. So this will be where the judge will sign an order saying this record is going to be expunged and it's going to be pulled out from the records. So what you will be filing initially, and I'm going to give you a practice tip for here in Orange County. I'm not sure what county you practice in. There might be a different process with the state attorney. But the first step, you file your petition, and your petition, your affidavit, and your proposed order are all going to be under the rules of civil procedure. So there you would find exactly what that will look like, and all you have to do is fill in the information for that client. And I can show you that as well at the end, a sample of what that would look like as well. So you're gonna file your petition, you're gonna file your affidavit, and then you're gonna file your certificate from Florida Department of Law Enforcement. I do not file the proposed order yet. And there's a practice tip here in Orange County. The state attorney here likes to get that proposed order first, and then they like to give 25 days for them to file a no objection on that. So I always send the proposed order first, have them see it. They normally take about a week or so to send me back a no objection. And then what I do is I go and send that proposed order to the JA of my judge, have them look at it. I send a copy of the no objection, and then I have the judge sign it and send it back to me pretty quickly. So that's how I do it here in Orange County. Seminole County and other counties might be a little bit different. And I always serve everybody involved. So once you file your petition, you file your certificate and your affidavit, I always serve the state attorney, Florida Department of Law Enforcement, and then whoever arrested that client. So it could be the sheriff's office, and I always send them by mail that the copy of everything that I filed as well. Once the judge, oh, I'm sorry. I think I'm having some issues. Oh, there we go. Once the judge signs the order, the last step will be for the client to pay the court costs and fees. So nothing can be expunged until that is paid. Normally, it could range from $45 to $75. It's not a lot. What they do with that is they send out a certified copy of the order to every single agency that's involved in that case, and they pull that record out. Always remember, and this is a very important thing that I always tell my clients, under Florida law, the judge has complete discretion to either deny that petition or not. It rarely happens. 99% of the time it does not, but it does happen where the judge says, I don't know if I want to do this. I don't know if I want to approve this. I want to have a hearing. It hasn't happened to me yet, but it could. So I always tell my clients, hey, you can go through the entire process. You can pay the fees. You can wait the long time to get to get a certificate back, and then the judge will deny it. It has happened before, but it's rare. So I always tell them, just in case, because you just never know. It's always better to be safe than sorry. So once you pay those court costs and fees, and this is a practice tip as well, that I always check 30 days after that is paid to make sure it was pulled out. Here in Orange County, the clerk of court takes about a week or two to pull the cases out, but I always give them up to 30 days to make sure that everything has been pulled out from their records and it's no longer showing. Once that's done, then the case is completed and closed out. And that's for expungement. So sealing, it's the same process. There's only a little difference on there, and is that you don't send it to the state attorney's office first. You just go straight to the Florida Department of Law Enforcement. So I put a statute here. This statute is a sealing statute. It's going to show you all crimes that, even though they might qualify for sealing, they cannot be sealed or expunged here in the state of Florida. And a lot of them have to do with sexual crimes, murder, and stuff like that. They do not allow you to get it sealed. And it's a pretty long list, so you can definitely go through that and make sure that your client's charge doesn't fall under that statute. If it doesn't, then like I said before, you will complete an application. You have the client sign it, notarize it, and then here's where you do not send it to the state attorney's office. You go straight to Florida Department of Law Enforcement. You're going to send in your application with your fingerprints, your $75, and your certified copy of the disposition of the case. You're still going to wait the long time of 9 months or so now because of COVID for them to send you that certificate and let you know that you're good to go. And like I said, you always send this certified mail with return receipt. It's very important. And you're gonna go and do your court case as well. So the same thing, you're gonna file your petition, your certificate, you're gonna file your affidavit. The sealing petition, the affidavit, the proposed order is all going to be in the rules of civil procedure as well. It's exactly what you have to put on there, and all you gotta do is complete it and fill in the blanks with your client information. Here in Orange County, I always, like I said, I send the proposed order first before filing it to the state attorney, give them the 25 days to object. They normally don't, they just send me the no objection. I send that to the JA, have the judge sign it and go from there. Like I said, they also have complete discretion under sealing as well to deny that petition. Rarely happens with the judges here in Orange County, but you always have to tell your clients that just in case. Once all the court fees are paid, then I wait 30 days from the time that the fees have been paid to the clerk of court and make sure everything has been pulled out from the records. And I will close my case on that. Okay, does anybody have any questions so far? I'm just gonna stop here because this will be the completion of the actual process itself before I move forward.
Thank you for that information. We do have some great questions that have come in. So the first one is, does Florida look at whether you've sealed or expunged in other states when taking the one sealing expungement into consideration?
No, actually that changed. They used to, but not anymore. So it's only for Florida. So if you've sealed or expunged something else in another state, that would not harm you here.
That's good news. And I encourage everyone to read the statute that Laura cited. It's quite interesting when you read through it. You're like, wow, this is really narrow. And I know I've been to one of the live trainings that her coworker did, and literally the room just empties out because the presenter was like, you can leave when I've told you enough that you know you're not going to qualify. There's like 2 people left at the end. So it's hard work, and I appreciate you teaching us all about this. Okay, so the next question is, someone with a felony who served time on his or her record cannot expunge or seal their record. Is that correct?
Well, it depends. Possibly, yes. So I've had a lot of people where they've done some kind of plea deal where they serve some time, even if it's a felony. And at the end, once their time is served, the judge would then put an adjudication withheld, which could possibly qualify. It depends on what crime it was or what
Okay.
they were charged with.
Is that more common in some of the special courts like drug court and mental health court? Is it?
Yes, juveniles.
Okay. And speaking of juveniles, great segue. The next question is, can a client expunge as a juvenile first for any juvenile record and then expunge adult charges as adult, or does the one-time rule apply to expunging both juvenile and adult?
The one-time rule applies to both. So I'm glad that somebody asked that because I had a client that had a juvenile record, and she was almost at the age of 21, and some charges do automatically seal, right? And they just come off at the age of 21 without going through a court process. And that would not count as her one. But if you do go through a court process for the juvenile record, then yes, it would count. So I just told her to wait so that it could be automatically sealed or expunged. That way, she still has that one in case she gets in trouble in the future.
Okay, so you have to be careful about which one you're choosing to seal or expunge. And I'm not sure if this question relates to the sealing or expunging, but hopefully it applies to both. Can it be filed in any county in Florida, or does it have to be the county where the charge was?
It has to be the county where the charge was. So I did not address that, and I apologize. But so you would file it in the same criminal case. So you would look up the same case in the county that it occurred, and that's where you would file the expungement or the sealing.
This is all new to us. Most of us legal aid attorneys just do not handle anything criminal related. So it's very educational to go through this with you. So the next question is, let's see. Oh, okay. Someone just had a clarification. I think they were talking about time served, if you could still steal or expunge. The way they do that is call the time in custody a time of probation. Otherwise, if they serve time, they must be adjudicated, and then they would not be eligible.
Yep.
So thank you for that clarification. And we have one more question so far. Can dangerous crimes be expunged or sealed, such as robbery or possession of a gun?
It depends. Again, I know it's weird. I'm sorry. I keep saying that. But so some of the crimes, if they qualify for sealing under that sealing statute, and I go back to it right there, some of them cannot be sealed. But if that same charge qualified for expungement where it was dropped, possibly. So it depends what happened at the end. If they had an adjudication withheld and it's one of those crimes under the statute, no. But if it was dropped, possibly.
Okay. So when there's that kind of case, do you go ahead and file, even if you're not sure if it's going to work, as long as the client is okay with paying the fees?
So, not exactly. So I always try to make sure 99% that they will get approved. I try not to file if they're not. So I definitely look at that statute, and if it falls under that statute, I do not file it at all, because I know that it's not going to get approved. If it's if I look at the expungement statute and it was dropped, then yes, then I would file it and say, I think you're going to be fined because it's not something that will qualify for sealing. But I always tell them, you never know, the judge might still say no, because even if it does qualify under Florida law, the judge at the end might tell them, I want a hearing, this charge is violent, I don't think I want to approve this.
Do you ever have clients who are afraid to go through this process just because they don't want to go back to court?
Yes, actually. And I always tell them this is not a criminal process. So sealing and expungement is civil. You wouldn't be doing a criminal case on this. And I think it makes them feel a little bit better that it's not going back to, the actual criminal charge. But I do tell them that, look, the judge is there to help you. A lot of the times, at least in Orange County, we've never really had a case where the judge has asked for a hearing and has been extremely tough, right, on the client. They always just sign the order and have it done and sealed or expunged. So I always give my client the reassurance that, look, and most of the times they don't even ask for a hearing. You will probably not have to go back to court at all. And if you do, then I'll be there. You're not going to go alone. Everything's going to be okay. But I always do tell them that a lot of the times you just don't go to court for it.
Okay. So there's nothing bad that could happen. You know, there's there's no downside to this.
You're not going to jail or anything for trying to get the sealed expunged. You're good.
And speaking of clients, Laura, bless her heart, is going to do this again on October 6th for the general public. So I shared that link in the chat box. So please share that on your social media and everything so we can get the word out, because there's so much need for this. Pretty much everything is a felony in Florida.
I know.
All right, that's it for questions. So go ahead and continue.
All right, great questions, guys. Thank you. Okay, so a couple of exceptions. Of course, Florida has to have this, because if not, it really wouldn't be Florida law, right? So under sealing and expungement, I always tell my clients, if they ask you about that charge and it's been sealed or expunged, you can legally lie and say you don't have that record, right? Except there's certain agencies in Florida that can still see it, and you do have to disclose it to them. So if you're applying for anything in the government that has to do with the city, the county, federal, any job with the government, they will always be able to see it, and you do have to disclose that you do have that. If you're trying to apply for jobs with seniors, children, or anything that has a license under Florida law, you have to disclose it to them and let them know that you do have it. So for example, doctors, attorneys, CPAs, nurses, they always have to disclose to those agencies that they do have that record. A lot of my clients do ask me why they should get it sealed or expunged if they're trying to apply for one of the jobs that have the exceptions. So I always tell them, let's say you have a hospital and you're applying to become a nurse there. The hospital tells you get it sealed or expunged, but I can still see that. Okay, the problem is when somebody tries to sue that hospital, because of something that you did, that third party, since they are a private party and they do not fall under these exceptions, they will not be able to see the record. So that's why a lot of those employers want that to be sealed or expunged. That way, even though they can see it, it will protect them from liability from somebody else looking into that past of the nurse or the doctor. So that's one of the reasons why they still get it sealed or expunged, even though their employer can see it. All right, so I'm gonna go and talk about a little bit of the background checks. This is not something that I do, but I've had a lot of questions from clients on this. I've had people come in where they're applying for a job at Walmart or somewhere else, and they tell them, hey, look, I had a record from 20 years ago, but it's not showing up on their background check. Should I still get it sealed or expunged? It just depends. So a lot of background checks going back to 20 years, it's rare. You would have to get an employer that's willing to pay for a really good background check that will go back far enough. Some of them go back 3 years, some of them go back to 5. So it really depends on how good the background check that the employer is using to find out what your record is, or if you have a record. So I always tell them, hey, if that job is not looking far enough and you're okay with having it there and not get it sealed or expunged, that's fine. Hold off in case in the future you're going to go to apply to another job where they go back all the way to when you were 16. Then you might have to get your record sealed or expunged if you do want to apply. So that's one of the things that I always tell people. I can't tell you what jobs would do a deep background check, what job doesn't. It really depends. But that's one of the reasons why some background checks pick up one and then they don't pick up another charge. Also, and this is rare, but it does happen, and I always tell my clients this once everything is closed out, even though your case is sealed or expunged, sometimes it comes up on a background check. Rarely, but it does. And the reason why is because that information has been sold to many different private entities in Florida. So even though the clerk of court sends out an order saying everything has to be pulled out, a lot of these agencies have been selling the record to so many that they can't catch up, right? So sometimes it does happen where it will show up on a background check, and what we do there is we have an attorney, a pro bono attorney that we send these cases to help them out. It's completely different from the sealing and expungement process. What ends up happening is that they have to go send the signed order to that agency that's still showing up, the charge on the background check, and tell them, hey, you have to pull this out. This was already sealed or expunged. And if they refuse, then they have to file a case against them. So it's a whole different process. I don't handle that part of it, but we do have an attorney that we send these to. So if you guys have any questions, I could put you in contact with them as well. All right. And then one quick thing I do want to address. So sealing and expungement is not to restore your right to vote. It does not restore your right to have a gun. It is only for when you're applying for employment or when you're trying to get housing. It will not give you your right to vote back, and it will not give you the right to have a gun back. That's a completely different process. It also has nothing to do with the governor. It's not a pardon. This is a completely different process for different charges as well. So this is a court process, and it does not include the right to vote or the right to acquire a gun. So if you guys have any questions, or if you're thinking of maybe wanting to take a pro bono case for us, that is my contact information. You can send me an email and you can call me. And I think there might be a couple questions, and then I want to show you guys how an affidavit and a petition will look like as well. So
great information. We did have one more question come in. Oh, two more. So what if a record has been sealed and they later get another conviction? Is the previously sealed record at risk of being unsealed?
no, it's done. So it doesn't go retroactively. The only thing is now you cannot seal or expunge anything else. And if they were convicted of that crime, that's fine. It wouldn't go back and unseal that record.
Okay, that's good to know. And generally, how far back do background checks go for a job or rental properties?
It depends. So some places, I know, I keep saying that, but it's true. Some places pay a lot for their background checks, and they can go back 20 years, or by the time that you're born till now. I mean, they go back all the way. Some of them only go back 3 years. Some of them only go back 5. Even with rental properties, a lot of them might go back 10 years or maybe 5. It really depends on how much they are paying for their background checks. Obviously, something that's less expensive, it won't go back as far, and it's probably not that good. Some places pay a lot for it, some places don't. So it just depends on how much they pay for their background checks and how good they do them.
Okay, it was really depressing to me when I heard that it could still show up on these private companies.
Yes.
So after you qualify for this narrow little process and you make it through, it's still going to show up.
Yes, after all that, I mean, it's crazy. And if you look into it, I mean, they sell it to hundreds and hundreds of agencies. So a lot of the time it catches 99% of it, but then there's like one that is still out there. And sometimes it doesn't show up, but there's that one rare time where it comes up still, and you're like, oh my God, now I got to go through a whole other case process. So, yeah.
Do you have any information to share about alternatives? Like, say, a lot of people are not going to qualify for this. So my limited knowledge is that agencies like Goodwill have lists of employers who are okay with felony backgrounds.
Yes.
They offer federal bonding to the employers as like extra insurance for encouraging them to take a chance on people with felony backgrounds. Are there other resources?
Yeah, so I used to do these seminars before the pandemic at Goodwill's. So I would go out, and it was part of their job search or their job program. And a lot of the times really it's just the employer. So a lot of employers are okay with somebody having a felony that can be sealed or expunged, or they're okay with having somebody that has a violent charge. So a lot of the times it really depends on what kind of employment as well. So if you're applying for retail, it's a little harder to get a job there when you have a petty theft charge. But maybe a battery, they're okay with it. It depends. I know I had a client that came in that couldn't seal or expunge, but they were working at the airport, and they didn't like that he had a battery charge, but they were okay with a petty theft charge. So it really depends on the employer and where you're applying to, but a lot of them are really forgiving, and they understand that you had a pass, it's gone now, you're trying to do something and get a job and be a better person. So a lot of them are okay. They're like, okay, we'll hire you and we'll give you a chance. And Goodwill is one of those resources where they would have a list of those jobs out there.
Okay, so that's some positive news. And I know you said you don't handle cases from other states, but do you have any information to share about, like, is Florida normal or are we special in this case? Are we particularly hard on this issue?
Um, so Florida is unique compared to
Always.
a lot of other states. We definitely have one of the longer process. It takes a lot longer for us to be able to get this done. A lot of places it's a little bit shorter, and I do believe, don't quote me on this, that there's some states that do multiple charges. So even if you've already sealed or expunged one, you can still do another one, which is good. Unfortunately, Florida is not that way at all.
Good to know. We're always special. So I don't see any more questions at the moment. So if you want to go ahead and do the demo of the different
Yes,
websites.
let me show you guys, and bear with me. I am not very tech savvy. As you can see, I kept scrolling through the PowerPoint in the middle of the presentation. But let me see if I can. Christy, did I stop sharing the screen? Oh, here it is. I see it. Okay, I'm going to stop sharing it, and then I will share it again once I get to that form. All right. Okay, so the first thing I'm going to show you is the Florida Department of Law Enforcement website. Okay, this is where you would go to get your application. So this is the main page right here. You're going to go to the left side where it says seal and expunge. And this right here is very important. So this tells you what applications they have started to process. As you can see, they just started March 2020. We are in September. And who knows how long they're going to be doing the March ones. So it takes a while, just so you know. So here, if you want to know exactly where they're at, you can go to the website and they'll tell you where they're at their processing stage. So once you go here, you're going to go to application, and it's going to be a fill-in. So you're going to pick, and I didn't talk about that here, but you can do juvenile records. It's a little bit of a different process. I don't handle those, but we are going to have a training at Legal Aid November 3rd, I believe, on juvenile. So if anybody wants to know about that, we have an attorney that's going to be doing the juvenile sealing and expungement presentation. So I can send that information out to you guys if you'd like as well. So you would pick expungement or seal. Okay, and it will pop up everything here. You're going to complete all of this information for the client. And then normally when you have something on here, it would generate a PDF. Since we don't have anything, I'm going to show you what it looks like when it's just a blank form. Once you print it out, it's going to look like this. Okay, so all the information is going to be completed here. This is where the client would sign and notarize, and the state attorney. If you have to get it expunged, your charges, and this is a fingerprint card. The fingerprint card is going to be printed out with the Florida Department of Law Enforcement application. So this is where your client has to get their fingerprints done. It cannot be a digital fingerprint. They can't go to a private agency. We actually just had a client who's been trying to get them done. The sheriff's office has been closed because of COVID, and they have not made appointments for fingerprints, and I contacted Florida Department of Law Enforcement to see if they would make an exception and do a digital fingerprint from a private agency, and they are not accepting that. They have to wait till the sheriff's office reopens, and they have to get them done on that fingerprint card. So this is what it would look like. Okay, and the sealing is the same thing. You just put seal, complete the application, and it's going to look the same way. So this is the initial application that you submitted, and it's also going to have their fingerprint card. It's also going to have the information of where you mailed it to as well. Okay, right here, you're going to mail it to this address, certified mail, return receipt. Don't forget that. All right, so I'm going to stop sharing this one so I can pull up the petition and the affidavit and the proposed order, how that would look like. And like I said, that's also in the rules of civil procedure as well. Let me All right, so this is what a petition looks like, and I've redacted all of my client information. So this is exactly how it's going to look on the rules of civil procedure. And all you're doing is filling in the blanks, okay? The petition, everything you have to have on there, and that's it. And you would file this with your affidavit and with your proposed order once the state attorney files a no objection on that. And let me show you the affidavit. The affidavit, you have to get it signed and notarized by your client. That's pretty much stating that everything in that petition is true and correct. So they definitely have to sign that and have to notarize it as well. And this is how the affidavit will look like. And like I said, this full template is going to be in the rules of civil procedure as well. There we go. We have the petitioner, which is your client, sign, and then we have to get that notarized on there. And this is what your proposed order will look like as well, just so you have an idea. There we go. Follows the same format. And then here's where your judge will sign it. And I will show you what a certificate will look like once you receive that from Florida Department of Law Enforcement. I do have a copy of that as well. Let me get that for you. There we go. So it's going to have your client info, it's going to have the case number, and it's going to tell you you are good and you're ready to expunge. And this is what you would file with your affidavit and your petition. And this is what takes 9 months for you to get right here. It takes a while. All right, and that is pretty much what I have for samples, Christy. I don't know if there's any more questions.
Thank you for showing us all the examples. That was really helpful. Would you be okay with me sharing those examples with everyone, like in a shared Google Drive?
Yeah, of course.
And is the PowerPoint okay to send out as well?
As well, yep.
Make sure. And by the way, you were a champ with the screen sharing.
Oh, thank you.
Not being tech savvy.
I was scared it was just gonna close out. I'm like, oh my God, I'm so close.
You did great. So we had one more question come in. Does the U.S. Postal Service do fingerprints for the FDLE form?
You have to get them done at a sheriff's office, so a police station. Any police station, they're not taking anybody else. They're very, very specific about that.
Okay. And where do you recommend that clients get the forms notarized, since our office
so in my office, I have staff that does it. So now during COVID, we are not allowing anybody in our office. Everything has been virtual. I know a lot of people that have friends that are able to do it, or anybody. I'm very kind of worried about these electronic type of notarization things. I don't know if they will accept it, so I wouldn't try and do that. I would try and go somewhere where it's still open to get that done. I know there's still a couple of places out there. There might be private individuals or private companies that you would have to pay for it. I think the clerk of court as well might be able to notarize or have a department that does it, but I don't know if they're open depending on where you're at.
Okay. And I'm not sure if everyone's libraries are open. I know mine is here in Polk County, and I found out by accident they do notarization as long as the one lady is there. $1 a page. I mean, you can't beat that.
Perfect.
So libraries might be a good resource. Oh, it looks like, let me see if we've got one more question that came in.
I saw that. Is it the trafficking, the human trafficking?
Yes.
Yes.
So let me read it out just in case anyone's joining by phone. This process and the steps differ from the 943.0583 human trafficking victim expunction process, correct?
Yes, it is. It is very different. So I didn't cover human trafficking. I don't handle human trafficking, but I can put you in contact with someone who does. It's not the same. It actually provides a little bit more protection than the regular sealing and expungement statute. So yeah.
Okay, so stay tuned for that. I don't know if we have anyone doing a training on that. And you mentioned that someone will be doing a training on juvenile sealing and expunging.
Yes.
So I'll
November
put that in.
3rd. I don't have the specific date yet, but I
Okay,
can send you that information if you want to send it out to them.
sure.
I know it's either going to be a live session or it will be a recorded session on our legal aid site. So I think on the 23rd of September, we're going to meet and finalize everything. So once I get that, I can send that over to you. So if anybody would like to do some juvenile sealing and expungement, please let me know, because it's rare for a lot of attorneys to do that. So
Do you have a lot of cases that need pro bono placement for adult or juvenile?
mostly for juvenile, because we just don't do it in house, and a lot of pro bonos don't want to touch it. It's a little bit different. So it depends on how many we have so far. We've actually been able to place a lot of the regular cases, the adult cases, quickly because of COVID. A lot of people want to do pro bono, which is great. Everyone's working from home and they're like, yes. Juvenile records are a little bit different. Those are a lot harder to place. I think it takes about 3 or 4 months more to be able to place that than a regular adult record.
Okay,
So if you
well,
want to do it, let me know.
yeah, if anyone has some spare time instead of sitting on I-4 to get to work, you can take a pro bono case instead. Well, thank you so much for all this great information, Laura. That was really helpful.
Of
I don't
course.
see any other questions, so I'll go ahead and end the webinar a little bit early so everyone can get to lunch. But thank you all for attending, and I'll get this up on YouTube and certainly let you know whenever the CLE comes through. It'll probably come through tomorrow. That's how it goes. We got lots of compliments. Great presentation. Thank you. So thank you so much
Thank
for
you
doing
guys. And if you have any questions, you can call me or you can send me an email. I'm always available.
it. All right, I'll send out the materials to everyone. Take care, everybody.
Bye,
Bye.
guys.